Even well, he has that one, but you're right.
Can you guys hear me?
Because you get all the door opens and closes and stuff. Oh yeah, you're right. That's terrible.
Okay, good morning everyone. My name is Dorian Jackson. I'm the Wills Trust and Estates Attorney for the Downtown LA Latif chapter. And today I'm going to speak to you about a new series that I started called Close Encounters of the Probate Kind. It's basically a series of articles that I'm writing about transactions that get close to probate, but that you can get out of relatively quickly. The first one that I'm going to talk about today, the first one in the series, is called A Study in Hegstad. So basically, whether you know it or not, the state of California has an estate plan for you. So that's called the intestate succession statutes. So if you don't set up your own estate, the state of California has one for you. So typically what happens is when people learn this, they set up their estate plan, their living trust. Now, the living trust is great, but a lot of people don't realize the creation of the trust itself isn't what protects you. You also have to what's called fund the trust. That means titling the assets in the trust. Now, this is typically where problems happen. For example, let's take a refinance, right? Normally, with refinances, and you guys can see Peter shaking his head, normally with refinances, the lender will require you to take the property out of the trust and put it into your own personal name. Now, this isn't necessary, but most lenders require it. The problem that occurs is if you forget to put it back into the trust and then the person passes away, we now have an issue because the property is not in the trust, right? So this could happen in this particular way, which is what happened recently. I'm actually working with a realtor who was in escrow, and the escrow fell through because they learned during escrow that the property wasn't actually titled in the trust, okay? This could also happen if your documents aren't prepared properly or not properly executed. There's various reasons why this can happen, but the problem is, once this happens, what do? Well, before 1993, what ended up happening is you had to do an entire probate. So, in other words, 9.5 months to a year and a half in probate court to get this property sold and to get the money to the beneficiaries, okay? However, what happened in 1993 was there's this case called the Estate of Hegstad. Now, in the Estate of Hegstad, the elder who created the trust did a schedule to his trust listing all of his real property as assets of the trust and indicating that in his living trust, that all of these properties were assets to the trust. Now, ultimately, one of the properties was not put into the trust, which normally would require a probate. However, the court looked at this and said, look, he intended this property to be in the trust. He said so in his trust that was properly executed. So we see no reason to force him to go through an entire probate. So they just granted the party's request for an order titling the property into the trust. Now, this case was a landmark case because it completely changed the way this particular situation is administered now in California. So after this case, a statute was created called Probate Code 850. And with this probate code now, as opposed to having to go through a full 9.5 to a year and a half long probate, what you do now is merely make a petition for an order from the court. It takes about 30 to 60 days, and you're done. And this all comes from the estate of Hegstad. So in these situations where you have a trust, but the property isn't titled in the trust, the key things that I would need to assist this person would be a copy of the trust, a copy of the Schedule A to the trust, listing all the trust assets, and the pour-over will. Those are the key things that I'm looking for. As long as I have those documents, I can now get these people out of probate a lot quicker with a Hegstad petition than having to do a full-blown probate. So that's the study of Hegstad, and that's why the Hegstad case is important. Old school practitioners, even though it's codified in Probate Code 850, will still refer to this as a Hegstad petition, though it's actually codified in the Probate Code. So that's a little bit on what I want to talk to you about today. So if there's any questions, please let me know.
I got a question.
Go ahead, Ryan.
So does the headstand ruling apply to only properties in California? Let's say I held a property in Texas or another state. Does my estate plan apply to properties in other states, or is this just in California?
That's an excellent question, actually. So the answer to that is somewhat complicated. When you can have a California trust control property in other states. So for example, let's say, I know you're from Ohio, let's say you have rental property in Ohio. You can put that rental property in Ohio into a California trust. Now, you raise an interesting question. If that property is taken out of the trust, I think there might be an issue, because ultimately in that situation, you're probating in 2 states. Because you're going to have to probate in Ohio, where the property is located, but you're also going to have to open up a probate where you were domiciled, which would be California. So in California, your Hegstad situation would be fine. I don't know Ohio law, so I can't specify as to what would happen. So that's a little bit of an unknown. But what I would say is if you do have rental property in other states, just make sure that it's titled in the trust and you make sure it's recorded so that it shows up on the deeds in the county recorder's office as in your trust. That way you're not going to have any problems. Because remember, one of the other ways you come into the Hegstad problem is if the documents aren't properly executed. For example, the person I told you I was working with, that they fell out of escrow, she sent me the Schedule A. Guess what? It wasn't signed. So now we have an issue because she didn't sign the Schedule A. So now I'm not sure if the judge is going to grant the Hegstad, and we still may have to go through a whole probate. So another concern that you're trying to alleviate is making sure all the documents are properly executed. Peter? Go to you next, David.
Yeah. If you have children that are over 18 years of age, I think you mentioned something about a healthcare directive. Is that what it's called?
Correct. Well, advanced healthcare directive. Yeah. What I was saying before is everyone over 18, at the very least, should have a power of attorney and an advanced healthcare directive. The reason why is, so I'll give you a personal example. I'm 41. I know I don't look it, but I'm 41 years old. My mom still calls me kiddo, right? So she's gonna call me kiddo to the day I die. She changed my diapers. Like, what am I gonna tell her, right? So you're always gonna be a child in your parents' eyes. The problem is, under the law, at 18 years old, you're an adult. So a lot of people forget that, and they think, oh, they're my kid, I can just make decisions for them. Well, that's not how it works, because remember, we have laws, like for example, HIPAA, which is a federal law. If the hospital is going to deal with you, they're going to have to give you the child's medical information. Now, if the child is over 18, the hospital is risking violating the HIPAA laws, because according to HIPAA, they can't disclose that without authorization. Doesn't matter who it is, because remember, the child now is an adult at 18. So if you don't have the advanced healthcare directive with the HIPAA release, then you could possibly run into problems. Same thing with the power of attorney. I had a friend whose good friend died at 25 in a horrible traffic accident. She wanted to get, her parents wanted to get pictures off of Facebook, and Facebook wouldn't give them to them because they didn't have a power of attorney. So these type of situations, I know you don't want to think about, but the reality is at 18, everyone should have a power of attorney and an advanced healthcare directive with the HIPAA release, just in case, because the last thing that you want to deal with is when something tragic happens, right? And remember, this is going to be an emotional event. So you're dealing with an emotional event, and now you're talking about having to go to probate court. You're talking about having to hire attorneys. You're talking about having to pay thousands of dollars. This is not what you want to be doing when you're grieving emotionally. So what I like to tell potential clients is, look, plan for this now so that when it happens, you don't have to worry about it. Because as charming as I am, the last person you're going to want to be talking to me when your loved one is in the hospital is actually having a conversation with me about probate court and the cost of probate court and my costs. Go ahead, David.
Yeah, two-part. One, when you brought up the lenders taking the
requiring the property to be taken out of the trust. Right.
Do you have do you know like the logical reason why the lenders really want to do that? And then the second part is, what other ramifications happen by taking the property out of the trust and putting it back in? Is there any other legal, tax, any other
No, tax-wise, you're not going to have any problem taking it out and putting it back in, because a living trust doesn't offer you any creditor protection. So under the eyes of the law, it's still deemed to be just you or whoever the owners are. As far as the lender question, I think what the lenders are concerned about is that technically the trust, when it's in the trust, it's technically, for all intents and purposes, a different person, but there's an easy way around that. What you do is you have the lenders, you have the borrower signed under their name and their name as trustee of the trust.
Right.
And then the problem's alleviated. But
any other situation would be considered fraud, like if you did it before bankruptcy, if you did it before, some other.
Potentially, right. I mean, we're depending upon the intent, but yeah, I mean that could evidence an intent of fraud. But for some reason, lenders, there's actually forms that exist for this too. All they have to do is fill out like a 2-page form, and the lender can do it. But look, I deal with banks all the time. Yeah. Banks have been dealing with trust for hundreds of years. I still don't understand why they don't know how trust works. Like, I'll give you another example. I always tell clients, when I set up their living trust, go to the bank and put their bank account in the trust, right? I'm going to give you the scenario that happens like 99.9% of the time, okay? I give them a trust binder. Now, a trust is a large document. My trusts are pretty small. They're like 25 pages, okay? These things, depending upon your net worth and how complicated you want to be, could be like hundreds of pages, okay? That's why they have what's called a certificate of trust, which is a short form, which gives you all the key information. It tells you who created the trust, who the trustees are, who the beneficiaries are, and what powers the trustee has. That's all the bank needs. So I tell the client, show them the certificate of trust, and they'll go to the bank, they'll show them the certificate, and then the bank is gonna say, we need to see the trust, right? I'm gonna say, no, you don't need to see the trust. They say, we need to see the trust. You give them the trust, it's 25 pages. They start flipping through it, their eyes roll over, and they just take the certificate anyway. So I don't understand why people do certain things with trust, because it's not necessary. It's just, people do. And you just have to make sure that you're protecting yourself when you're dealing with professionals that are not necessarily knowledgeable about this stuff, because there's a lot of them. So you just have to make sure you protect yourself so you don't end up in one of these situations. Go ahead, Ryan.
So back to the healthcare directive you talked about, is that something that a husband and wife would also set up for each other, or is that specific to?
Excellent question. This is one of the biggest things that people don't understand, and when I give my little estate planning speech, this is what they go crazy over. So most people think, like I was just talking with a relative of Peter's yesterday, and I was telling her the same thing I'm about to tell you. So most people think if you're married, you have control over your spouse. So if something happens to your spouse, you clearly have the right to go to the hospital and tell them what to do. No, you don't. Remember, they're an adult, right? And again, HIPAA, it's a federal law. If you violate that, that's a big source of liability for the hospital. Now, I'll give you another example. Let's say, something happens to, let's say we have a married couple. Something happens to the husband, wife makes a decision. Let's say it's the second wife, right? And the kids don't agree with the decision, okay? Let's say there's no advanced health care directive and a HIPAA release. And then let's say something goes wrong and the husband dies. Guess what? What do they have, Mohammed? What kind of liability is the hospital looking at? You're a personal injury attorney.
I'm sorry.
So if we have a husband and wife, the wife makes say it's the second wife, right? So it's not the mother of the kids. There's no advanced health care directive. There's no HIPAA release. The second wife makes medical decisions for the husband. He ends up dying. Let's say the kids are upset with the mother.
Or medical malpractice.
Or wrongful death, right?
Yeah.
Okay? That's just a huge lawsuit for the hospital right now. So ultimately what's going to happen, the hospital may make you let decisions for a while, but at a certain point, it's going to come CYA, okay? And they're going to say, look, we can't make any decisions without the right paperwork. I'll give you another example. I had a neighbor whose child was quadriplegic. So he basically, totally incapacitated. Couldn't even speak. He drooled all over himself all the time. And I don't say this to disparage him. I'm just saying to indicate the kind of mental or lack thereof capacity that he had. At some point in time, the hospital, once he turned 18, they told her, even though she was the mother, she was the caretaker, she still had to get the advanced healthcare directive. So because he didn't have capacity, she couldn't get it. So I had to go to probate and get her a conservatorship. Okay? So you have to remember, hospitals are deep pockets. Deep pockets are targets of lawsuits. They are going to become incredibly concerned at a certain point because they don't want to be the target of lawsuits. That's the reason they lobbied the state of California to cut the, pain and suffering to $250,000? because they don't want to have to deal with all these big lawsuits and paying out all these money. So to end it up, yeah, every married couple needs an advanced healthcare director with a HIPAA release as well as a power of attorney. There's no legal rights for one spouse to another. So with that, we'll wrap it up, and thank you, everyone.
So if anybody needs a trust or any probate information, I reached out to Dorian yesterday because my uncle has a situation, my aunt's not well, and I've been beating on him for a long time to get a trust. And who knows? I mean, Dorian, if he can do it, he's going to do it for me and my uncle. But he is definitely the man for trusts.